Hi, thanks for using my court coach. I'm Sarah and I'll be your instructor today as we talk about the request to stay or for a termination of stay of service of an earnings assignment order, also known as Form FL-455. As with all our court forms, you want to start off by filling in the identifying case caption information at the top. Generally, when the court issues a support order, it is also automatically authorized that you can submit a wage garnishment, also known as an income withholding or an earnings assignment order to enforce those support payments. However, if you would like to ask the court to stay that garnishment, you can fill out this form, or vice versa. If you have previously agreed to stay the garnishment, you can ask the court to terminate that stay. If you are filing this separately from a hearing on support, you do need to get a hearing date from the court and give notice to the other side. There's a section for that below. So if you are applying for a stay, well, first of all, you need to indicate if you want to apply for a stay or a termination stay at the top. If you are applying for a stay, then you need to check one or more applicable reasons right here under application for stay. Either you have paid fully and on time the previously ordered support for the last 12 months and you do not owe any back support, or you have not been subject to a support order for the last 12 months but have posted a bond with the clerk of the court and the amount that you posted that to equal to 3 months of support and you do not owe any back support. If you can show that the service of the earnings assignment would cause extraordinary hardship on you, and you need to state the reasons and be prepared to prove those reasons at the hearing by clear and convincing evidence. If you have a written agreement with the party receiving support that provides for a stay, and if that's the case, you want to attach a copy of the agreement to this form. If the employer or local child support agency that is helping with the garnishment has been unable to deliver the payments to the recipient for at least 6 months because the recipient has not updated their address with them, you would check box 5, and then you would want to attach a statement under oath by your employer or local child support agency. So you would fill in your name at the bottom, sign and date. And again, if you do need a hearing on this, then if you're in a county where you can call up the court clerk and they will give you the date and time over the phone, you can go ahead and list that here. If you're in a county where you have to go to the courthouse to file the documents and the clerk will fill in the information, leave it blank for now. Address is either going to be as shown above in your case caption area, or if there's a different address where this hearing would be taking place at, list that right here. Below is different than what we filled out above. This is if you want to ask for a termination of a stay, then you would fill in this section. So if there is a stay previously issued in this case, you want to list the date of that stay and then check the boxes that identify the reasons why you're asking for that to now be terminated. So option number 1, the person required to make payments has missed at least one payment of support which continues unpaid. And by the way, it does warn you that a false statement about missed payments is punishable as contempt. 2, if you are the person required to make the payments or the local child support agency and you're just requesting for the stay to be terminated, in other words, you want to be able to have your wages garnished. And item 3, if the reasons for granting the stay no longer exist, then of course that can be provided why those reasons no longer exist at the hearing. There is some space here to state the facts in support of that. And if this is not enough space, you can always attach a sheet of paper to this and just say see attached. Fill in your name at the bottom, sign and date. And then this will need to be served by mail to the opposing party. So you're going to have someone that's over the age of 18 and not a party to this case do the service for you. They're going to list their address here in item 1. They're going to state the date they deposited this form in the mail, the date of deposit, place of deposit, city and state, and who it was addressed to. And then they're going to fill in their name at the bottom, sign and date. This will get set for hearing. And at the hearing, the judge will make his orders onto whether or not there should be a stay, there should not be a stay, etc., whatever relief you're requesting. And then once the judge signs it, this becomes a court order. I hope you found this helpful. Good luck.